tonight, as we've mentioned, from Connecticut all the way to New Zealand. We appreciate you taking the time, I guess, to come out tonight or tomorrow morning for our Land Trust Law School session with Keith Ainsworth. We called this Tree Law, Encroachments, etc. Keith has a much better name for it, which you'll see in a moment. But just to do a little bit of housekeeping, as many of you know, this is part of our virtual series, Conserving Land by Staying Connected. And for those of you who don't know me, my name is Rebecca Dahl. I'm CLCC's program manager, so I'm the one you're getting all of these fun little emails from. I will hand it on over to Keith Ainsworth, who many of you probably already know and have likely seen respond on our Land Trust ListServ, because he is truly a Land Trust ListServ rock star. So Keith, go ahead and take it away.
Yeah, some might say Land Trust ListServ obsessive compulsive, but anyway, I want to thank everyone for being here. As you know, I'm an attorney in private practice in New Haven, currently located during the pandemic in Madison. I'm a life member of the Madison Land Trust, and so I'm actually one of you guys and represent many land trusts throughout the state of Connecticut. What I'd like to do is start sharing my screen so you can see the slides, but I'll just introduce that. Let's see, here we go, share screen. And let's see if we've got it. So let's just make sure that I can advance my slides. So I now have to, oh yes, see, we had this problem before. Yes, okay, so I'm gonna go back. All right, so this is the Pandemic Earth Day edition. This is the second time I've done the Land Trust Law School virtually. I prefer to do it in person. First of all, I like seeing everyone at the CLCC conference. It's probably one of my favorite events. I see all the people I talk to on the phone and talk to through email, but this is so much more pleasant. And so we're going to cover just a few slides. I've got 17 slides. So that forces you to all come up with questions. And if you don't, I'm going to prompt you for some topics. You'll see a slide on that. But I'm going to make a shameless plug. I am also the current chair of the Council on Environmental Quality for the state of Connecticut. And the annual report comes out every year around Earth Day. We tried to make it come out almost on Earth Day, but this year, a couple of days in advance. So I've got the link up there. If you go to the CEQ's website, it is one-stop shopping for environmental issues. It covers indicators for how things have gone. There are winners and losers. We actually talk about those kinds of things. One of the losers, unfortunately, was open space. We're not actually meeting our open space goals, or at least we're not on track to. Losers were also included lobsters. The population still continues to decline, as well as bats. These are probably not all that unknown to you. Some of the winners are that we've had success in air and water quality. We re-added wetlands back into the report because we've had problems with the data accuracy, but we decided that something is better than nothing because wetlands are so important to the state of Connecticut. Anyway, so I'll move on from my shameless little plug. You can get it on the website. There's an interactive version that's pretty helpful. All right, so I'm going to start out with the classic topic of tree liability. And as you know, or as you can probably tell, I did some of my own artwork to avoid the intellectual property concerns of stealing things from the web. But this is probably one of the perennial issues that came up, and I did an entire presentation just on tree law this past fall. But so I'm going to give you the sort of the short version, and if this prompts you to come up with some questions, feel free to ask them when we get around to that part of it. So here's the basic rule. Trees on private property don't have to be pruned or removed because they're natural conditions. The courts have repeatedly said, look, you're not responsible for things of nature. And it's actually called the law of ferae naturae, which is wild animals. But it also applies to wild things like plants. So that's the basic common law, and it has not been changed by statute, although the legislature, it's not for lack of trying. The legislature has made 3 attempts at least to make landowners liable for trees that fall. And so the basic rule is, and let me repeat that, it's that landowners, including land trusts, are not liable for trees that fall from their property onto something else. So for example, a tree that is dying or perfectly even healthy, it gets hit by a storm, falls down, lands on your neighbor's car. No, you're not responsible for that. They're likely covered by insurance, but you would not be responsible for that because it's not something that, there has to be negligence. There has to be some action that causes you to be legally responsible. You're not just legally responsible in strict liability for a tree. Now, of course, the exception to that rule, and it's a very important exception, if you do anything that makes it more likely the tree might fall and do damage, then you, of course, would be responsible for that because you've actually taken an action that, caused something to hurt someone else. So, but other than that exception, you're not responsible. Now, I can't tell you how many times I've had to debate with other attorneys and other clients who've said, you've got to be kidding me. I get these letters all the time that say, I've had an arborist look at that tree. It's, it's diseased, it's dying, it's going to fall, it's going to land on my cat, and you're going to be responsible for giving me a replacement cat. In New York and some other states, there is a rule that if you provide an arborist report to a landowner and says that that tree is in danger of falling and it may hurt someone, it then shifts the responsibility to you. That rule does not exist in Connecticut. They've tried to pass it here. And specifically because the legislature tried to pass it and didn't, that's actually made the rule stronger in Connecticut. Because the courts, being a separate branch of government, have to give deference to the legislature. The legislature creates our laws. The courts apply the laws to the facts. And so what the courts have said so far is that specifically because the legislature tried to create the rule and failed, they actually knew about the problem, but didn't change the law. That means that the court isn't in a position to legislate on its own. And so I've got an example of one of those potential statutes that was not actually passed. And actually that's where this sort of mythology has come from. A lot of people are under the mistaken impression that you are responsible if someone sends you one of these letters. Now, of course, I'm an attorney, and we always have to give you the disclaimer. All the law so far has been superior courts and not an appellate court. The appellate court, when they speak, it's binding on all the other courts below it. A superior court, another court can disagree with them. And so could this rule change? Yes, if the right circumstances occur. And there's been 1 or 2 cases that kind of hinted at what that circumstance might be. If you're in a densely populated area, like an urban area or a dense suburban neighborhood, you're deemed to know a little bit more about your property than, let's say, wild open space where it's all unoccupied and you're not there. You may be stewarding it, but you're not present to examine trees, and you may be stewards to literally tens of thousands of trees or so many trees that it would be impractical to ever inspect them all. As a result, there's a difference in standard for someone who resides in a let's say in a city lot that's maybe 1/10 or 2/10 of an acre, where you may have 7 trees. You know each one of those trees very intimately and would know where they're about to, when they're about to expire, fall, or be a threat. So, but even that rule has not been passed or applied by the courts. So I always go through a list of the statutes that apply for landowners and land trusts. There are, I think, a dozen, maybe 2 dozen laws that I have in a list. I've given a handout to the CLCC. If you email me or you email Rebecca or Amy, they have a copy of my full handout with all of the statutes. It's sort of one-stop shopping for all of the statutes that you might think you would need to be aware of if you were a land steward. But I'm going to feature 5 not so random ones, but ones that I think are interesting. And the anti-slap suit provision, and I've talked about this before in other presentations, but it's actually a really interesting concept. We were late to the game. California and a number of other states passed it long before us. But basically what it says is if someone sues someone participating in a public process on First Amendment grounds, if you're speaking about political issues, but I'll keep it to the environmental realm. If you're speaking out about protecting property, let's say a lot of land trusts don't get involved in zoning hearings or wetlands hearings unless there's a project adjacent to their own property that might impact it. But occasionally you have occasion to speak on, on a matter in a public forum. And there's an old tried and true tactic that some developers have used, which is to file a suit against someone who maligns their project or maligns them in the process of a permitting or public forum. And they basically try to intimidate people into not speaking. And that's called a SLAP suit, a strategic lawsuit against public participation. And I've seen it happen a couple of times in my practice, not often, but it actually worked in one instance. I had a client who ran for the hills and wouldn't continue. And so this statute basically says that you can dismiss those suits and get your attorney's fees and costs for filing a suit against you for speaking out in an environmental forum. That's new from 2018, so it's a relatively recent enactment. The encroachment statute, of course, is my favorite. It's a perennial, and I will always talk about the statute. It's the single most powerful statute that I know of in environmental law. I've been practicing environmental law for 30 years, both federal and state, and this is more powerful than Superfund because it actually has a quintuple damages provision. I haven't seen a situation where the quintuple damages provision has been applied by the court, but we haven't run into a circumstance where it's been so outrageous that the court has felt that it should get hit that hard. But multiple damages are definitely possible, and the fact that it's in the statute is provides a great deal of leverage for a land trust. So what this statute basically says is if you damage or encroach on protected open space, the owner of that protected open space may file an action to seek not just restoration or the value of the lumber, which is what it used to be, but actually the restoration of the environmental services. And I don't want to make a shameless plug for any product, but I'm holding up, if you're looking at my in the corner of my screen, I've got the Guide to Plant Appraisal, which is the 10th edition, 3rd printing, it just arrived yesterday. And it is, I think I'm probably one of 2 or 3 people who have it other than the libraries. But it is referenced in the encroachment statute that says that if you encroach, that you are liable for the damages for that you do to the landscape, in addition to the value of the plant's material damaged as calculated under the Guide to Plant Appraisal. So it actually incorporates by reference this book. And I'm not going to recommend that anyone go out and buy it unless you're actually involved in dealing with the legal end of things, because it's actually a very technical book. But it actually has methodologies that are scientifically developed by academics for talking about how you appraise the damage to the natural resources, not just the value of what it takes to replace a tree, going out and getting a nursery stock and replanting it, but actually stewarding that tree and the environmental services that are lost in between the time that planted tree gets put in and when it grows to maturity as to where it was. Let's say it was a 70 or 80-year-old tree. You plant a 6-year-old tree. It's going to take probably 20 years, maybe 25 years to get to ecological parity. And that results in some fairly interesting calculations. And I'll show you a couple of examples in a minute. Then there's the park replacement statute, which is one of my favorites. I've actually got a case right now in New Haven, and it basically says that if a municipality takes a municipal park and uses it for something else, like a school or a dump or apartment housing, that they have to replace it with equal size and value property. And they have to hold a couple of hearings to do that and put notices in the paper. There's a lot of public participation process. And it's actually a really good statute. It was passed in the early 70s, and for probably about 20 years, nobody even knew it existed and ignored it. Interestingly enough, it was passed when New Haven took a couple of parks to put up some schools. And I actually currently have a case against the city of New Haven where they took a public park to put in some housing. And we're trying to make them replace that park with equal size. What they've done is they tried to create some pocket parks, and you can't actually, in my view, do that because the ecological value of a larger parcel is not equivalent. Is not made equivalent by taking two smaller parcels in two other locations, because fragmented open space, as we all know, is not as ecologically valuable. So that's an interesting statute, and it's been ignored for most of its existence. There's only been a few times when it's actually been used, but I've been noticing that some attorneys have been picking up on it. Connecticut Environmental Protection Act, of course, is the basic environmental injunctive act that allows you to protect property. I often use it in conjunction with the encroachment statute. It also, 22A19 is the sister statute to it, which allows you to intervene and become a party to public proceedings so that you can advocate for the environment. I threw in the running bamboo. It's a little bit of a random one, but one of my personal favorites. I handle a lot of these bamboo cases, but running bamboo, I've seen it all over the state, and it's a really pernicious plant. It's actually a tree under the Connecticut definition of trees, which is any single stemmed plant that grows over 15 feet tall. So it's actually more closely related to grass, but under Connecticut law, it's actually a tree. So that's how I'm tying it into the land trust talk, and I'm standing by that. Okay, here is what my handout looks like. I know you probably can't read this because that's minuscule print, but the intention is just to let you know that there is a handout that's available from the CLCC, or if you email me, I'll send you a copy. I'm happy to do that. If we were doing this in person, I would have copies. Okay, so as they mentioned, the ListServ, the ListServ that's maintained by UConn, that is for the land trust. There are some wonderful questions that come up. People come up with the most interesting topics, and I try to only weigh in on those things that I have some knowledge on. I try to resist the temptation to answer almost every question. It's kind of like a quiz show for me. And for an environmental lawyer, it's like catnip. So I'm going to just show you what I would consider maybe some prompts. If you're thinking about questions or you haven't thought about a question, here are some topics that came up in the last year and a half on the ListServ. And the first one, actually, I added this afternoon. I had a question from a land trust, which is actually not the first time I've actually heard this question, which is, can I buy land trust property? In this case, this is an encroacher who asked, after having encroached on the land trust, can I buy the piece of property? And which I said is the definition of chutzpah. But in addition, they doubled down on that. They actually defined doubling down by saying, well, it's pretty beat up. And of course, they were the ones who did it. So then they tripled down on that by saying, and we'd like to buy it for the assessed value, or less than assessed value because it's so beat up. So there's an interesting topic. This comes up occasionally. Can someone buy a piece of land trust property? If it's protected, if it's got a conservation restriction, it requires a court order to do that. So, and the Attorney General's approval, which is not going to be easy to get. If it's unrestricted land, it certainly can be sold. But you would obviously have to use the proceeds for something related to the land trust mission. But obviously there's some real, what they call optics problems with that. Your potential donors are going to be concerned about whether you're really stewarding the lands that they might donate to you or did donate to you. But there are times when a piece of property might have had property around it develop in ways that isolate it and make it of low conservation value. And if you were to sell it to an adjacent property owner, you might be able to realize a value that you could apply to properties that are of greater conservation priority. But in the case of an encroacher who asks to buy the property, usually the answer is no, because you don't want to encourage encroachments or reward them. But if you were to get a multiple of the value of the property, you might be able to justify that. But again, in my own personal opinion, I think that's a bad idea. Some of the other topics are, whether you should allow hunting on land trust properties, what to do about off-leash dogs, and of course, we'll talk a little bit about recreational use immunity. Land trusts, by the way, are not liable if they do not charge money for the use of their property. And now, if you just did a one-off, you had a special speaker and you charged to defray the cost of the speaker who was doing some sort of wildflower talk or something like that, that probably would not break your recreational use immunity for all time, but it would probably mean that if someone got injured on that particular instance, that you would lose your recreational immunity for that one instance. If you did it enough, however, you might lose it for all time, because the concept of recreational use immunity is that because you're a nonprofit and you're not competing in the commercial marketplace, then you can be given this immunity and you're not unfairly competing. But once you start charging for things, then there are other people who would say, hey, I'm a commercial business, I charge for doing outdoor education. Why are they immune and I'm not? So so you, as a land trust, you need to be careful about how many events you have that you charge for. And I will say there is no number, and it just is that with every time you do it, you are more likely to lose your recreational immunity for the times when you are not charging. Mountain bikes, are they allowed or should they be allowed on land trust property? An interesting debate, obviously got very hot on the listserv, so I probably should stay away from that one. I have some very strong thoughts about that. Whether a land trust can bar a rule breaker from a land trust property. Actually, you can, and I've done it. I've actually advised clients to bar someone who has done damage to a land trust. And you may say, well, isn't that antithetical to public access to open space? It is. However, if someone breaks the rules, just like a private property owner, you can say you've lost that privilege. And that helps, because once you tell them that in writing and you've got a documentation of that, you can then use the laws of criminal trespass if they do it again. Obviously, it's a fairly strict thing. You don't do it to every person who ever encroaches. It would only be for a more serious or repeated offender, at least in my view. Another question that came up was nuisance beavers and what to do about them. I'll talk a little bit more about that in a bit. I got a question about, or there was a question about an avigation easement, which is a plane oversight or overflight and landing easement, a very particular thing. I didn't know what an avigation easement was until I got my first question about it. And then there's affidavits affecting interest in real property, which is a statutory provision that allows you to file an affidavit saying there's an encroachment problem between us and our neighbor, and usually a dispute over where the boundary is. And if you file that on the land records, the next person who buys it buys with knowledge that that's there. And it's helpful in resolving a particularly difficult boundary dispute without going to court, because it puts pressure on the person, because when they try to sell or transfer their property, they have to justify to the buyer why this thing is in the land records. Now, of course, you may wait an awfully long time, because if someone wills the property to their heirs, their children or grandchildren, it could be generations before that resolves. It's not exactly the most aggressive way of dealing with an encroachment. Land trust tree fall policies. Actually, one of the questions that came up before the session that was mailed into the CLCC was about are there tree fall policies, and I will answer that question later. Fencing off water access, whether you can block water access was another question. Surveyor stakes came up as a question. And surveyor stakes, when you put them up, Temporary stakes are actually in a gray area of the law, but there is a law that actually makes it a felony to move a surveyor's mark. And it's unclear whether a wooden stake would apply as opposed to a concrete or iron pin, but the law is actually generally interpreted to be the more permanent markers. But so when you do a survey staking, those are supposed to be temporary, but interference with a survey stake within a short period of time would probably be considered a violation of that law. There have been questions about green burials and dispersals of ashes on land trust properties. And of course, I'm repeating myself with the tree policies. So my next slide is, what do these three slides have to do with each other? The beavers, the bears, and the bees. Well, that was one of the questions that came up was what I called the bear bait and switch. It was probably the story of the 2020 ListServ. There was a property owner adjacent to a land trust who opened a bear baiting operation, and the land trust in Connecticut DEP made an agreement to intercept and ward off the bears before they reached the bear baiting operation. And the operator of the bear baiting operation, which was illegal in the town, but not illegal in the state, interestingly enough, by state law, threatened to sue the land trust over tortious interference with their business because they were interfering with the bears traveling from the area where they were baiting the bears so they could feed them and have tourists take photographs of them. And this is where I was talking about the law of feri naturae applies. There are a couple of cases where the state of Connecticut has talked about whether or not someone is responsible for what beavers do, where beavers build a dam, the dam breaks and it floods somebody's garage. Is the person who is host to the beaver responsible? Not if the beavers made the dam by themselves, because that's an act of nature, not an act of the property owner. However, in one instance, this Briere versus Tuzia case, the beavers actually made a dam in the breach of an old impoundment that was breached and dammed it back up, and then it breached. And what the court said was, well, the beavers, what they did was natural. However, the landowner maintained the berms that the beavers used to build their dam in between the broached impoundment, and said, so you were actually maintaining a man-made condition and made them responsible for what the beavers had done. I thought that was an incorrect decision, but that's actually the law of Connecticut, that beavers can sometimes make you responsible and sometimes they can't. And in New Hampshire, they determined the same question with regard to bees. If you have a beehive or that you maintain, you're responsible for that. If it's a wild bee colony hanging in a tree or under your garage, then you aren't responsible. You are not responsible for it. And therein lies the sort of the fundamental underpinning of a lot of environmental law in the common law of Connecticut, which is why we aren't responsible for trees. Beaver bonus round. This came straight off of the ListServ. Somebody posted this. This is just comic relief. Actually, I shouldn't denigrate it, but there's actually nonviolent rodent conflict resolution. I didn't know there was a Beaver Institute that actually would put people in touch with folks who will keep you from having to shoot them. And actually, in all seriousness, a lot of people resort as soon as they see beavers to eliminating them, as opposed to maybe putting a pipe through the dam to allow water to flow through and not back up so much and not pose so much of a flooding threat. Okay, so we have some, and actually let me just take a gander at the time, make sure we're keeping, okay. So I'm gonna go sort of quickly. This is going back to the guide to plan appraisal. The encroachment statute, incorporates the guide to plan appraisal. I already covered that. Here's an example of where someone said that they didn't do this to get a good view of the Hammonasset River that's behind there. This is an actual encroachment case that I had. And if you look at those trees in the foreground, those are probably 55-inch, 60-inch trees. He claimed the guy was actually not very, he had, let's say, the equivalent of a desk job. And he told me he did all of this cutting by himself with a chainsaw, which the court actually found credible. Not that I did. But in this instance, you had, actually, I should go back. In this instance, we actually used the guide to plan appraisal, and we had our experts testify. They testified. The court awarded damages and attorney's fees, and that was fairly good compensation. However, there's other examples. Land trust with new owner with a chainsaw, and I made this generic. But this is very common these days. We've got a lot of people moving into the state, buying up properties, and they're coming from places where the rules are different or their ethos is different. And people are coming in and just obliterating land trust property left and right. It's happening with a great frequency during the pandemic. And I don't want to malign our New York neighbors, but it's a thing. So in this case, we have a new neighbor in the Northwest Connecticut. They cut 617 trees and shrubs. A lot of it was just pole lumber, and their explanation was, "I thought we had permission," which is typically what I always hear. The land trust hired a forester who estimated about $600,000 in damages. The land trust also hired another forester who estimated it only in 59 to 65. Of course, what they did is they just undermined themselves. And what happened was the land trust hired actually none of the experts on either side of the case used the guide to plan appraisal. And the guide to plan appraisal probably would have come in the $600,000 range. And they probably ended up settling, in my estimation. Obviously, I don't know what the settlement was because it wasn't my case. But they settled probably at about $50,000. And so the lesson here is, you need to use the guide to plan appraisal. And if you're doing an assessment of an encroachment, and this would be for you, not just for your attorneys, if you have a stewardship committee that's doing encroachment work, in dealing with it, if you have someone go out and estimate the damages, you need to know that they understand that that your expert, your forester, your arborist, is using the appraisal process in the guide to plan appraisal. And frankly, I'll admit, nobody in Connecticut uses this book because it's an academic book that doesn't have much of a practical application. It's just a statutorily cited book. And it's also extremely detailed. And so a lot of the arborists actually don't know how to use it. This is another encroachment case. You'll see in the foreground both a survey stake, which was the boundary of the land trust property, which is on the far side in this photograph, and you'll see a no trespassing sign. And here is actually what the neighbor had their wood chipper tree remover going in to do. And in that case, they cleared another half acre, only 68 trees. We used the guide to plan appraisal to come up with a $375,000 appraisal. That case actually settled for $125,000. This book is worth its weight in gold because before that book was referenced, people were paying for, the nursery stock replacement value, which is extraordinarily minimal. Here's another one, another Northwest Connecticut land trust. This one, actually, I just wanted to show you this picture because the landowner, when we confronted them over this, said it was the storm damage from Irene. And I don't know, it looked a lot to me like it was a chainsaw because storm damage doesn't usually have cuts that are really smooth like that. Which is why photographs are worth, pictures worth 1,000 words. If you see an encroachment, having a baseline is one thing, but getting photographs of the damage quickly after it's done so the evidence doesn't erode is another thing. So same thing here. We have another one, 3/4 of an acre, 81 trees. And, we've got, an initial offer on that case of 120,000. Again, it all comes down to using the formula. So I'll open it up to questions now. This is really the part where I really enjoy, interacting with you all. So I'm going to stop actually sharing my screen so we can all see each other. So.
Thanks, Keith. And I just want to make a quick reminder. I know for many, it may be easier to share your questions aloud. If you can use the raise hand function before asking your question so that we can kind of file you into a queue and see where you are. And Carol, I see your hand is up. So please go ahead and feel free to unmute yourself and ask your question. Carol, do you want to unmute?
Yep. Can you hear me now?
Yep.
Yes.
Okay, I typed it in the chat. I was just in the process of typing it. I'm wondering if you can give us more details on where we get our hands on this guide to plant appraisal.
Okay. And I do want to say, I get no commissions from this, and I'm actually not endorsing the book as something to, not all of you need to have it, but your arborist needs to have it and needs to understand it. But it's put out by the International Society of, the International Society of Arboriculture from, in this case, Atlanta, Georgia. And it's the 10th edition, which is from 2019, but actually it's got a new printing this year. And if you go to the ISA, International Society of Arboriculture website, they do offer the book. It's about $195 for non-members. But like I said, if you've got an arborist who you rely on, they should be familiar with the book for encroachments.
Thank you.
All right. Harvey, I do see your hand up, but we did get a number of questions come in advance. So I'm going to just sort of popcorn back and forth a little bit. One of the questions I received via email was, I just minimized it, pardon me. How necessary was and is it for the state of Connecticut and utility companies to remove trees along roadways? This person's understanding was that removal of trees actually weakens remaining trees and makes them more vulnerable.
Okay. Well, there's a whole statutory scheme that applies to utility trimming. Whether it's necessary is a judgment call, but there was a PURA docket, the Public Utility Regulatory Authority, which governs utility tree trimming. And the utility company the utility authority ruled that the utilities cannot use their emergency exception to their rules to trim any tree they want. They used to say any tree that was in danger of contacting the wires could be trimmed, and that's true. If it's in contact with the wire or very likely to hit it, they could trim. But what they did is they started interpreting it as, well, anything within a distance of 15 feet on either side. And the PURA said, no, you can't do that. And now they're actually changing their rules. They're challenging that. And so there is a process by which, if you go to your local tree warden, you can appeal the trimming of trees because they have to give you notice. And under their emergency powers, they don't have to give you notice. And that's why they were doing that. So they didn't get the notices out. They didn't have to respond to the tree warden. So get to know and love your local tree warden. They can be a good friend, and they can be very helpful in that. Do they have to trim? They do actually have to do some trimming because it's just for reliability of the system and also for safety. But the utilities typically interpret that as a much broader responsibility than it probably needs to be. Legally, though, there is a system for getting notice, appealing it to the local tree warden.
Excellent. Harvey, since your hand's raised up, do you want to go ahead and unmute and ask your question? And then I'm going to go back to some of the earlier questions in the chat.
So I found it very interesting about your law. If it happens naturally in nature, it's not, land trust is not responsible. So we have a pond with beavers, and the beavers are blocking a culvert that is draining the pond. So the pond is filling up and pretty soon it'll be over the roadway. Are we legally responsible for the damage that those beavers are causing by flooding the roadway? Or are we responsible because it's our culvert?
Actually, what's really interesting is that's almost identical to the beaver case that I was citing to you, that Borson case, or Tesia case, where the beavers dammed up the breached culvert or the breached impoundment. And because the impoundment was maintained by the landowner had a duty to maintain that impoundment in a responsible fashion. Even though the beavers had contributed to it, the landowner also had a responsibility for the portion that wasn't done by the beavers. In this case, I think that might apply to your, in fact, it probably would apply to your culvert pipe, because the culvert pipe is a man-made structure that you have a duty to maintain. And for whatever reason that it gets plugged, you would have a responsibility to clear it out. So even though the beavers did it, in this case, the court would likely focus on the man-made structure part of it. So the answer is, nah, beavers aren't doing you any favors.
Okay, well, we are using the Beaver Institute for help, so.
There you go.
Great.
Uh,
All
and I
right.
didn't mean to make light of that.
Just to jump back to a couple of the questions that came in early in the chat from Rob. If a dead limb on a neighbor's tree is hanging over your property, may you lawfully cut the limb?
Yes. It was, the law of Connecticut for 300 years, in fact, has been that you may cut up to the boundary, any plant material that is up to your own boundary. So if the trunk is on the other person's property, you can cut up to, the boundary between the properties. If the tree exists on the boundary line, you need to have the permission of both parties to cut the tree down. And you can't do anything that would kill the tree. Like if you cut all of the roots on your side and it killed the tree, you might be responsible for a boundary tree. But otherwise, you can cut up to the boundary, which is what's called the Massachusetts rule, but it's really, I think we had it first, so it's actually the Connecticut rule.
And then another question in the chat, perhaps this will come up, but what about liability if a limb or tree injures a hiker on our property?
Oh, unfortunate. That's where recreational use immunity comes in. And I quoted that statute earlier, but there's a statute that basically says if you're not charging people to enter that property, and you didn't charge that person to enter the property, then you are immune. So it's an unfortunate accident. I mean, if you're hiking in the woods anywhere, you could be hit by a falling limb. But that doesn't mean that you would be responsible unless, and there's the exception, unless the land trust had done something to that tree, like you had made a trail and you had somehow damaged the roots to that tree or otherwise damaged the tree itself and caused it to be in a condition where it might be more vulnerable. So, but absent, if it was just a natural event, no.
Excellent. Carol, just so you don't forget, I'll go ahead and ask you to unmute to ask your question, and then we'll jump back to the questions in the chat.
Okay, thanks. I have a question about a utility company. Can a utility company is moving lines on a land trust property, and they're telling us that we should move our trail for one. And also, my question is it assumed that are they required to return the property to its original condition? Do we need to find the language in the easement or right away or whatever it is they have? Or is that an assumed condition of that they have to return it to the original condition? And do we have to move our trail?
Well, let me just ask one question. Is the trail on their property with, or is it, and you have an easement to put your trail across it, or is it your property over which they have an easement?
It's our property and they have an easement.
Okay. So the terms of the easement will control, because an easement is basically just a written document that gets filed on the land records that gives someone rights to another property. And there is no statutorily required language. So they're drafted by an attorney at the time. And they can say almost anything. So the terms of the easement will be what you'll need to go to first. So if there's ever actually an easement problem, you always get a copy of the easement and review that first, because the language in there can differ infinitely from any other easement. Although there is a standard easement that Linda Francois will probably talk about in one of her presentations. That model easement has only recently been promulgated and is not as widely used. And of course, easements have been around for decades and decades. So there's a lot of ones that are out there. So to get back to your specific question, they might have to restore the property after trimming, and they might even be able to tell you to move your trail if it interferes with their easement rights. In other words, if the trail is too close to utility structures that might cause there to be a safety issue, they might be able to say you're interfering with their easement rights.
Wow. Okay.
But it really depends on that's really going to be a very fact specific situation. You have to know the parameters of where the trail is, what kind of utilities are there, and what the easement says.
Where can we get a copy of the easement, since, as you know, land trust boards members change over the years, and where are these papers?
Actually, that's a really good question. Easements, because they're recorded on the land records at your town clerk's office, all of the easements, even if your land trust doesn't have good records, any easement that was ever given to the land trust or given by the land trust to someone else should be recorded under the name of the land trust or the owner of the easement in the grantor and grantee indexes in the town clerk's office. And if you need assistance finding it, usually the clerks will help you. But there are also title searchers who can do a thorough review for $100 or $200 or so.
Okay, thanks. Great information. Thank you.
Excellent. So to come back to some of our questions from before, the next one is there a definition of passive recreation in the Connecticut General Statute in regard to land purchased with state funding? There is one about 20 years ago that was vague with regard to bicycling, and now we have the added challenge of e-bikes. Hope this doesn't venture too far into biking for you, Keith.
Okay, is there a definition of passive recreation? That's interesting. I actually don't know, because there's a lot of statutes that might implicate that term, but in terms of its relationship to open space, I am not aware of a definition of a statutory definition of passive recreation. But generally, passive recreation is generally considered to be anything that doesn't involve vehicles. So a bicycle might be on the cusp because it's man-powered or human-powered, but probably would be considered to be active recreation. Whereas passive is walking, hiking, bird watching, maybe dog walking, but not things like organized sports or kayaking, boating, and anything that involves equipment probably would not fall in that definition. But you've prompted me. I'm going to actually I'll search the statutes to see if there is a definition.
Can't see who it was, but I think someone was clapping in favor of that. So the next question I have on the list, regarding sale of land that doesn't have any conservation restriction, can the town tax assessor come back and collect back property taxes?
That's more of a PA 490 question. Okay, and PA 490 is the statutory reference to the forestry and farming open space assessment statute, where you can put property into a lower tax valuation. And so, yes, if you don't keep the property in open space for at least 10 years, there is a recapture tax provision. And if you're saying that, well, the property was taxed in the past as open space, but not in PA 490 or not in the farming or open space assessment program specifically, if it's just taxed lower because it's just undeveloped land and held as open space, no, because what would happen is it would have been taxed appropriately because it was held as open space before that, and then its use would only change upon transfer to the new property owner. So, oh, and I see John Troiano said this question may be in reference to the fact that land trusts don't pay taxes. Well, but that's the whole point, is that land trusts who are nonprofits are nonprofits when they held the property. So it would only be taxable when it was transferred to a non-taxable, to a taxable use. In other words, to a nonprofit. So if a land trust transferred it to another nonprofit, it would remain as at the nonprofit rate. If it was transferred to a commercial entity or a private entity that used it for another reason, it would be taxed at the normal rate that land was taxed at. So interesting question. But it raises a number of more complex possibilities depending on the facts.
And just because this came in while you were answering that question, Keith, I'm not sure if they're fully related. There's a question: the town took a school ball field / recreation area and built a parking lot, and now they have installed raised solar panels over them. Is this in violation of what you were talking about before?
The park replacement statute.
Okay.
Well, remember, the statute doesn't prohibit someone from taking the park. It only prohibits them from taking it and not replacing it. And of course, they have to hold the hearings. So it would be a violation if they didn't have the appropriate notices. And there's actually, you have to have the notice 15 days before, and then not closer than 2 days before the hearing. And then you have to hold a public hearing on where you talk about the land being taken, the value of the replacement land, and the quality of the two, and why you chose to do that. And if they didn't hold that hearing, that's a violation. And if they didn't actually replace it with equal size and value, then yes. Now, remember, there's actually a case in Derby, I think, that I had some tangential involvement in, but was taken over by someone else who pursued it. And what happened is, in that case, the deed that was held by the town actually said it was for municipal, park, open space, and other general municipal purposes. And because of that last phrase that said other general municipal purposes, they built a water tank on that property. And the court said, well, wait a minute, it may be open space and it may be a park, but it also is for other purposes. So if it's not exclusively for a park, then it might not be a violation. And remember, even if the property was not donated with a deed restriction that says it's a park, it can still be dedicated as a park by public use. And this is an interesting quirk of Connecticut law that I always found kind of fascinating. I still do, is that if someone holds out a piece of property as a park and the public uses it as a park, let's say someone being a town, the public can actually end up dedicating the property to public use as a park if that's how it was used. And regardless of whether there's a deed restriction, the park replacement statute will still apply. I found that a little surprising because it's a little inchoate and undefined, but that's how the law works in Connecticut. Excellent.
I'm going to ask one more question that came through in the chat, and then I'll pop over to our folks who have their hands raised. So this question came up during some of the case studies that you were sharing. Is the encroaching neighbor liable, or the tree service which removes the trees liable? So this is some of the clear cutting that you're showing.
Actually, I've had that case in particular where a tree service was hired by a neighbor. Oftentimes it's just the neighbor who does it, but yes, both are is the short answer. Because and now remember, you can sue both, but as a practical matter, the tree cutting service would be able to go back to the person who told them to do it and say, hey, you hired me to do this. You didn't tell me where the boundaries were. Or however, the owner could say, hey, I told you to cut the trees on my property. You didn't go and look. So both of them would have a responsibility to know where the boundary is. And in fact, we recently, on behalf of a land trust, filed a suit against both in order to put some pressure on both. Because we weren't actually sure if one of the parties had sufficient funds to pay for. So we figured that the commercial entity would have a commercial insurance policy, and insurance is always a good thing.
All right, Scott, I see you came up first, so feel free to unmute and ask your question.
I was going to ask a question as to whether so-called notable trees are given any special protections in Connecticut?
Short answer, not any more than any other tree, although notable trees are usually of particularly large size or particularly valuable specimens. And so under the Guide to Plan Appraisal, calculation of their appraisal of their ecological value, the number would probably be higher than, let's say, an ordinary white oak or birch or beech or whatever.
No, that's not quite what I meant. There's this group, and I don't know who they are, who designate notable trees, usually by size, and put plaques on them and so forth. And I'm wondering if those trees, wherever they're located, are granted any special protections. For example, if a notable tree is on your property and you decide it blocks your view and you want to cut it down, has nothing to do with the land trust, but are environmental entities empowered in any way to protect such trees? My guess is they're not, but I thought I'd ask.
Okay. I'm unaware that there's any statutory or even municipal provision for a notable tree protection. I think the designation is one of more of an honorarium. But in terms of whether or not someone could do a 22A16 injunctive action to protect a notable tree, it would have to be a particularly unusual specimen of a native tree that was somehow endangered. And even then, I think the court would take a very dim view of someone attempting to use the statute in that way. So I think the answer is going to be no, although I think someone could potentially fashion an action, but I wouldn't want to be the one to do it. Just being candid.
Awesome. And then Priscilla, feel free to unmute and ask your question.
If a town takes over a park for some other purpose and they agree to replace the park, is there any requirement that it be accessible to the same community that used the first one?
That actually is one of the issues in my case with New Haven, is that they're replacing, they were offering to replace the park with a couple of smaller parks in other parts of the city that are about a mile away. And in a city, as you know, it's very neighborhood oriented, and people will, they might go to their local park, with a stroller or whatever. But if it's on the other side of New Haven, it's not easy to get there. You have to either take a bus or you have to take a car. And it's difficult to get from one side of New Haven to the other. It's a fairly long walk. And so I would argue that yes, it should be in an urban setting. In a, let's say, non-urban setting, I think that, first of all, there's no restriction in the statute that it says it has to be replaced in the same area. But I would argue in an urban setting, the context says yes. In any other setting, if they replace it with equal value, which is monetary value and ecological value and size, I think they would be free to do it no matter where they did it. Although I think it would be very questionable. I've never seen someone attempt to replace it in another municipality. And frankly, for a municipal park, it would be very strange for a municipality to try to replace their park in another town. So I don't think I'll ever face that question.
Excellent. And then the last question I have from the chat is, when a new surveyor marker disappears and the neighbor says that he didn't do it, yet they're doing construction very close to said property line, do we have any action? And then it goes on to say, also, he argues that our survey is wrong. What is the document we should file in case in the future sale of the land and the border, if there's a dispute there?
Okay. Well, I mean, any neighbor can, and this is not unique to land trusts. I mean, any property owner can survey their property and have a surveyor stake those the boundaries. And if you disagree with it as another adjoining neighbor, the only response you can have is to get your own surveyor to check their work and either confirm that they're accurate or not. And if there is a dispute between the two, you can either go to court for what's called an action to quiet title to determine the boundary, if it's a serious enough thing, or you work it out with them. But if you can't, there is, I mentioned that that statute that allows for an affidavit regarding a dispute as to real property. And this is exactly what it is commonly used for, which is, hey, I dispute that the boundary is what you think it is, and you put an affidavit on the land record saying that there is this dispute. If they want that taken off, they would have to file an action against you to resolve that issue, or you would have to file an action against them to resolve it. And so if they were to transfer the property in the future, that affidavit would show up in the title search by the attorney who's doing the title search for the transaction. And then the attorney would say, hey, there's this affidavit says there's a dispute. What do you want to do about that? And the buyer's going to want that resolved before they go through the closing. And John Troiano just asked another question. Can a private property owner make an adverse possession claim against a land trust? And absolutely not. There's a statute, it's 47-27B, which is a statute that basically just says that land trusts enjoy the same sovereign immunity as to adverse possession as railroads and the state of Connecticut and municipalities. So no, you can't make an adverse possession claim against a land trust. There is a mild exception to that. If the land trust acquired the property after the adverse possession had been established, they might be able to claim it. Although if it had not been judicially determined before the land trust took possession, that case has never been tried. I think the land trust would win because there's a policy that says if you've got a right, you should exercise it. And if you don't, and then circumstances change to where a land trust acquires a property, that you're out of luck because you sat on your rights.
Excellent. Priscilla, I see your hand is up again, so feel free to unmute and ask your question.
If we go back to the question before about boundary disputes, if the dispute is actually about where an easement line is crossing private property, where part of it is under easement, part of it is not, do you have go through the same legal recourse of filing with a town that there's a dispute?
Interesting. You remember that's not a mandatory thing. It's an option. But in that case, you would be the landowner, and by filing the affidavit, you don't really affect. You affect your own title, not the title of the other party. However, so you might want to file the affidavit within the chain of title of the other party who holds the easement rights.
But if we hold the easement on someone else's private property.
Right. Okay. So if land trust holds, or someone holds an easement on someone else's property, there's a dispute as to where those are, you would then use the same affidavit to file on the property owner's chain of title. And again, that would come up in the title search. Again, as I sort of warned, it could be generations before that issue needs to get resolved because a grandchild or great-grandchild might not care. Or actually even a new owner might not care. They might just say, who cares? So it might not get resolved by that method. It's a very, very weak strategy, but it is something you can do that's very inexpensive.
So Keith, we've had a couple more questions come in through the chat. Pardon me, I'm just going to make sure we're all using our audio well. So the first question is, in determining the tree replacement value in the first example, Pyrone's tree maintenance book was used. The site was in the middle of nowhere, so the tree location values used were very low. All of the trees cut were saplings. I think the original high value figure was not appropriate because they did not make any account for the remote location. Thoughts?
Obviously, these things are all site specific. But what I found curious was that the guide to plant appraisal process was not used. There's an actual calculational workbook that one fills out, and it's fairly generous to the ecological context. And so what happened in that case was that the argument was made that nursery stock could be put in place and put at a much lower density, and that would be a healthier way to restore it. And the emphasis was being placed on restoration as opposed to the appraisal of the damage done to the ecology. And it's a different calculation entirely. And that's the difference between a traditional restoration project that someone might do in front of a wetlands commission where, hey, we've impacted a wetland and we're going to do a wetlands mitigation project, or we're doing some forestry cutting and we're going to replace it. That's a practical and let's say cost-effective or cost-driven calculation as opposed to ecological services driven. And that's why the guide to plan appraisal isn't really used in general practice for non-encroachments situations, because it talks about things that most people won't take into account on their own unless they're forced to.
Great. I have one more question in the chat, and then Priscilla, I see your hand up as well, and I'm going to just make a note of the time. That's 7:39, so we've got just about 5 minutes. So the next question is, what are our obligations if a neighbor is concerned that one of our trees may fall into their property and in their mind is a hazard? What if we disagree, i.e. if it falls, it will fall into the field and not on a structure. They fear their pet or children may be playing, and if it were to fall, then they would be hurt.
Okay. And actually, that's very similar to one of the questions that was emailed to you in the days preceding this seminar. And so I did want to get to those two questions because I actually answered them, and I wanted to get to them because they were those attendees were nice enough to submit those in advance. But so that question falls under the same rule that I articulated at the very beginning, which is that just because they perceive that it's a problem doesn't mean that the owner of the tree is responsible for it, even if they inform them of it, because it's a natural condition. And so unless the person who owns that tree is doing or has done something that makes the tree get into the condition where it might fall, let's say they poisoned it or they damaged it or otherwise, dug a trench around it that made it looser, any of those kinds of things, then they might be responsible. But otherwise, it doesn't matter how much subjective or even objective fear these people have. It's really, did someone do something to make them negligent or to give them a duty to not act in a way that causes harm to someone? And so actually, I'd like to pull up those questions that came in. Someone asked a right-of-way question, and it was a deeded 40-foot right-of-way. And actually, I probably shouldn't do this, but I'm going to share my screen. And you'll see the question as I'm looking at it. And the question came in: a deeded 40-foot right-of-way was granted to a land trust for access to a preserve, has been encroached on in the form of a tree and earthen berms in order to mitigate flooding, which is a valid purpose, but that legally doesn't make a difference. The land trust is considering negotiating an agreement with the offending neighbor to allow the berms to remain in order to maintain the neighborly relations. The right-of-way isn't being used. And so my answer here is, if the tree just grew into the right-of-way, the land trust could trim the tree or remove it in order to maintain their access. Because if you have an easement, you're entitled to maintain the easement to allow you to have access. The owner doesn't have a right to sort of allow or plant trees or even just let trees grow over it and inhibit your access. If you have access, you're allowed to maintain the access. And the earthen berms, however, are not natural conditions. So your neighbor has definitely encroached if that berm makes it more difficult to use your access. And so that would be an encroachment that you could enforce. Now, to the extent that you want to make an agreement, we'll talk about that in a minute, but would the agreement prevent a claim of adverse possession? So here it is: adverse possession does not run against land trusts, and here's the statutory site. So they wouldn't have a claim for adverse possession, But even for non-open space parcels held by private individuals, not land trusts, an agreement which licenses or permits someone to do something breaks adverse possession. So if I give you permission to walk across my property to access a lake or whatever, the very act of giving permission is a license, and therefore it cannot be adverse possession, which is open, notorious, and adverse to my ownership. If I give permission, of course, it's not adverse. I'm giving you permission. And of course, it has to be for 15 years. What components of the language would such an agreement need? You could do an agreement and you could do a license, but a license only runs to identified individuals. It doesn't usually run with the land. That's called an easement. And so you could do either an easement, which would be unusual if it were temporary. You could probably have a time-limited easement, but it would be more appropriate to call it a lease and do a lease agreement to allow someone to do something that you might want to revoke later. Licenses are revocable, and easements and both leases are something that you would have termination provisions, and you'd want to have things that would allow the lease to apply for other owners, and you might want to provide for a fee, a nominal fee, or something like that. And then, what other concerns would such an agreement raise? A conditional or revocable lease could raise liability issues, because if you're allowing someone to do something, you could be held responsible for the conditions on that within the leasehold as a lessor. But I'm getting into an area where it's going to get very, very fact specific. And then I had another question on fallen trees, and I'm not sure if we probably covered this, but it says, upon notification of an abutter that trees on their property are dead or at risk of falling into the property, if we, the owner, let's say the land trust, inspects and concludes that it might be at risk of falling, and conclude that if it were to fall, it might damage something, and they said they historically have paid to remove the tree, which is a policy that you can have. And I don't recommend it, but you can do it as a neighborly gesture. Is there any basis to require the homeowner to pay for some of all of this? No. I mean, you can ask them, but you can't make them pay for something that you're doing to accommodate them. And now, if the abutter says, puts a shed under the dead tree, and of course now is creating a much greater probability that some damage is going to occur. One, I think that would be contributory negligence, which is basically they did a thing that was kind of foolish that would cause them to be partially responsible for any damage that occurred, because you don't build things under something that might fall on it. But even then, unless you did something to make it fall and it fell on their shed, their insurance will cover them, but they can't sue you for it. Also, I would make a recommendation that you not go out and make an assessment of the risk of falling trees, because you only do that if you're trying to determine whether you should pay for it. Since you're not legally responsible to pay for it, you probably shouldn't be going out and determining these things, because if you do that, that's the kind of thing that a court might say, well, you took an action and you assessed a tree, you determined that it might hurt someone, and now you have knowledge and you failed to act. In that case, the court might say the traditional law does not apply. So in this case, it's kind of a situation where looking and assessing the condition of a tree might hurt you. And then someone said, can we dispute, whether this is a hazard? And I said, look, if it's only going to hit the lawn, then, you're under no obligation to do anything, and you shouldn't. If it's going to hit the house and you know that, I've just given you sort of the scenario. You can, on an accommodation basis, trim the tree if you want to. But again, if once you go down that road, I think you're creating more hassles for yourself by precedent and potentially getting into that area where a court might actually start to say, hey, you're doing things, and once you do affirmative actions, you have a duty to do them responsibly. And then if we, okay, and I sort of covered this part of it, that question as well, which is if we conclude that it's not at risk of falling and we disagree with them that it's going to fall, you aren't obligated to take their opinion. And so you shouldn't do that. And then someone said, we probably going forward would have to regularly inspect the tree in the future with an arborist prospectively. That's why you don't want to start this process. If you start inspecting, you probably have a duty to continue inspecting, because if you say, oh, wow, it's almost going to fall, you probably either have to take it down, or if you say, well, it's not going to fall down now, but it might fall down soon, then you're going to be under an obligation to follow up on that. So this is a very interesting compound question, and that's why I took the special care to answer it. And then someone said, do land trusts have written policies that govern their decision making in this area, and can they be shared? I pulled out a couple of generic ones. One that was posted on the ListServ and one that I actually drafted. The first one is from the one that was on the ListServ, and I won't go through it. I'm just going to scroll through it so you can review it when you review the video, and I can send these to you if you'd like. And then I have another one, which is this one, the land trust tree policy, which is actually from a land trust client of mine that I helped draft this. And it basically says, look, we maintain our land primarily in its open, natural, and scenic condition, which is actually the definition of open space under our statutes. And we understand that sometimes this results in something that might be a concern to you. Longstanding Connecticut law says that trees are natural conditions and it's an act of God. The legal principle is that, the person whose property it falls on is responsible for it, not the person from whose property it fell, unless we did something to cause it. And then explains the law, and then says, to be a good neighbor, we may try to help solve a tree problem. However, please note that such efforts are solely at our discretion. If you're going to post this on a website, you want to have that disclaimer, which says it's at our discretion, because if you start saying things and you publish things, you've created a rule that you're going to hold yourself to, and you might be abrogating the law that protects you against this kind of thing. And then there was a comment that was attached to it. It says, this might be a problem because of all the, emerald ash borer and oak blight and all that. Yes, there's a lot of dead trees around. I mean, I've got 7 or 8 ashes on my property that recently have started to snap in half.